All right. So there was a fascinating decision. And when I say fascinating, I'm unlocking, David, a lot of my own legal career history here. Out of the Ninth Circuit on an issue that was honestly one of the most prominent First Amendment higher ed education issues in the nation 15 years ago. So if you're going to rewind the clock 15 years, I would say that one of the biggest issues that I face in my career, going back to Fire days as president of Fire, even going back before then, when I was the first member of the Fire Legal Network, to when I ran the ADF Center for Academic Freedom, was the clash between free speech and non-discrimination laws. And specifically, the clash between religious student groups' ability to have leaders who didn't just subscribe to a statement of faith, but a code of conduct sort of in line with traditional Orthodox Christianity on sexuality that would say the sexual activity is reserved for a relationship between a man and a woman. Or some of them, it was even broader because they would say you have to agree with the statement of faith and the code of conduct. And the statement of faith said, you have to believe. It's a classic Christian like Apostles' Creed kind of statement of faith. And people complained against these groups on two grounds. One, that's discrimination on the basis of sexual orientation. The other one was that's discrimination on the basis of religion, which that latter point never really landed because, of course, a religious student group is going to have religious criteria. And so that was always sort of the weaker of the argument. So it'd be about like saying, we're not going to allow college Republicans to exist on this campus because they discriminate on the basis of political status. Well, of course they do, right? The harder issue was always the other prong, which was a sexual orientation non-discrimination provision colliding with a religiously motivated code of conduct. And how would that play? And there were sort of two thrusts of cases. One line of cases was essentially, look, this was the combat between the non-discrimination clause and free speech and freedom of association and religious free exercise. And in general, as a general matter, as it all shook out, the religious student groups tended to win those cases because the non-discrimination clause in some parts was, it only listed specific criteria. So other forms of discrimination were okay, and this form of discrimination was not. And so essentially what courts were saying was, wait a minute, you're allowing some groups to discriminate on some bases and not allowing other groups to discriminate on other bases. And sometimes it was arbitrary. What's a recognized student organization versus another kind of student organization? And it got very messy. And these cases, by and large, were resolved in favor of the Christian student groups. Okay. Then there was an innovation in another case. This was CLS versus Hastings, a Supreme Court case, where what the UC Hastings College of Law said was, wait a minute, it's not really a conflict between a non-discrimination clause and freedom of association. We're going to say that every student has to be eligible for leadership and membership in every student organization. So it wasn't so much a non-discrimination clause as a all-comers policy. And in that case, the CLS entered into a stipulation that the all-comers policy was applicable and that it wasn't viewpoint discriminatory. And so therefore, that case was fought over the all-comers policy. And in a 5-4 decision, the Supreme Court ruled against Christian Legal Society in this very specific case of an all-comers policy conflicting with CLS's religious tests. And this was, quite frankly, David, the last significant religious free exercise / free speech loss for religious plaintiffs before the Supreme Court of the United States. And it was more than a decade ago. But the cases had almost no resonance across the country. Why? Because all-comers policies are actually almost impossible to enact truly. Because what would an all-comers policy mean? Well, you can't have men's intramural sports. You can't have women's intramural sports. You can't have fraternities. You can't have sororities. You can't have a men's glee club or a women's a cappella group. Or you can't have. And so, as just a practical matter, an all-comers policy just doesn't work. Okay, so let's fast forward, and I'm going to stop filibustering here in a minute. Let's fast forward to the present day, and Fellowship of Christian Athletes had long had a chapter in a high school in had long had a chapter in a high school in the San Jose Unified School District. And this chapter required that student leaders affirm a statement of faith, which includes the belief that sexual relations should be between the confines of marriage between a man and a woman. A teacher finds out about the statement of faith after this chapter has been there forever and launches an absolute crusade against this group. Like just an absolute crusade. So here's his teacher. And Peter Glasser, he gets copies of the Statement of Faith and Sexual Purity Statement from other students. He says the statements contain objectionable moral stances on marriage and sexuality, that he had to react right away to the viewpoints because any delay in his response could have been interpreted as agreement or even worse, apathy. So before his first period, he posted the statements on his whiteboard with a note: "I am deeply saddened that a club on Pioneer's campus asks its members to affirm these statements. How do you feel?" And that launches this really intense attack on this club, and includes, and Glasser puts in an email, we move right to the question of whether FCA's views need to be barred from a public high school campus. And then he just absolutely lambasts their views. And so, to make a long story short, the campus bars FCA, but then to do so enacts a version of an all-comers policy because it can read Supreme Court case law, and CLS v. Martinez is the governing case in the area. But it does something interesting where it allows, David, for discretionary opt-outs, for discretionary, to allow clubs on a discretionary basis to opt out of this. So, for example, a girls' club could be open only to people who, quote, identify as girls, or a guys' club only to people who identify as guys. So some of the clubs are able to opt out. Case goes up. The district court rules against the FCA. Case goes up. Ninth Circuit ultimately ends up en banc. And en banc, the Ninth Circuit says, look, the case law's developed since CLS v. Martinez. And under free exercise clause analysis, if you have that discretionary opt-out, if the officials have the ability to opt anyone out of the policy, well, you're done. You're done. This is Fulton County. This is, you got to satisfy strict scrutiny. You're done. You're out. And then they also go and overrule a prior precedent from 2011 that would have, in the Ninth Circuit, that would have disfavored FCA in the Ninth Circuit. But it was essentially, look, 1 ounce of discretion here to public officials, and you just lose. Yeah, fascinating case.